for their internal communications, and people in different countries communicating with each other using the Twitter thing, whatever you call Twitter.
Is it more free speech than material support? Like, yes, you are organizing, but
Yeah, well, how's it different from providing them software? We need software to facilitate our internal communication. We buy it from an American company. How's it different? Right?
Well, I think that's where as a sort of medium, and they're not essentially supporting the terrorist organization. The terrorist organizations are just getting their word out, and it's for people in the U.S. that are using this sort of Twitter feed. It's advocacy and not necessarily support.
Twitter is engaging in advocacy?
For the people that are using it. It just comes from media.
Well, they may be using Twitter in code or something to tell their brethren in the next country, here's the next strike that we're about to do. But they're using Twitter to make that happen. Who's doing the advocacy? Is it?
well, I was just going to say something about distinction between like software and like a Twitter page. Like software you have to buy, it's like it has a tangible like monetary value to it, whereas a Twitter page doesn't. Like, Twitter as a company has monetary value, but like you don't have to pay to use Twitter, and like you don't have to pay to like deactivate a Twitter or anything like that. Like, it's a free service you can sign up for, and like there's like I think that for me at least in the way that I interpreted it, like a material support is something that has a tangible monetary value to it.
Has to have a tangible military value. Monetary value, you say? Huh. What about the people in the Holder case, and what was the tangible monetary value that they were providing there? You could say, I think, the lawyer's time and effort, they usually charge fees for that. They're providing services. Services are within the definition of material support in the law. So that could be, would this be good policy? Lay aside our constitutional concerns for the moment. Would this be good policy for Twitter to shut them down? Can't use it. Is that the case?
I feel like that would alienate us as a country, honestly, because Twitter's a multinational business corporation, and for us to make a policy that, I mean, because I don't think Twitter would have to do that overseas, but they would have to do it here while they're operating in the United States. I mean, I don't know if that's actually how it works, though.
Mm-hmm. Nicole?
Mm-hmm. Like that YouTube case where, you want that video because now, but, where do you cross that line where business people that put on whatever not that?
I wonder whether if Twitter were ordered to or chose to close the accounts of people who were obviously associated with Hamas and Hezbollah, whether that would be effective. I mean, wouldn't they very quickly figure out some end run, some back channel way of being heard, John?
Yeah, I think your point, I think, wasn't stop them from like changing your name or going to a Twitter name. But then you would have to, for people that are using it, even in this case where it's like, you have 20 terrorist groups, well, what if those terrorist groups decide to change your name a little bit? Then you have to adjust the list accordingly, and all of a sudden it becomes
Yeah. Okay.
Well, none of the, at least if it's on Twitter, then we can see what's going on. It's pretty public.
Uh-huh.
So,
Uh-huh.
I mean,
What difference does that make?
in ways it allows us to monitor them legally.
Yeah. You must have been talking to Jonathan Zittrain, who's a professor at Harvard Law School and founder of the Center for Internet and Society, who said, the FBI is going to learn more about Hamas and any organization by having them operate in an open environment than if its voice is driven to proxies and underground back channels, which would inevitably happen right away. It's contrary to the First Amendment, as openness is the enemy of extremism and fundamentalism. So, I tried last night to find out whether Poe, the Texas congressman, had introduced legislation that would require Twitter to cancel the accounts, and I couldn't find anything, and I rather doubt that he has done anything. I'm going to digress for a second here, just a little bit, into a non-First Amendment issue, but is related to this subject. And it's the one that came out a couple of weeks ago. Well, it came out when we killed al-Awlaki in Yemen a couple of years ago with a drone strike, and we continue to use drone strikes in various countries to eliminate what the government says are terrorists who are responsible for or plotting against the United States. A couple of weeks ago, you may have noticed that a Department of Justice white paper discussing Department of Justice position was leaked to NBC News. The white paper was a legal justification for the use of drone strikes to kill American citizens, al-Awlaki was one, who are in some other country, without any trial, without any public procedure of any kind. And the government has an executive order that forbids assassinations. So the Justice Department undertook in this white paper to explain why these drone strikes against American citizens abroad those weren't assassinations at all. There is a memorandum, or maybe a series of memoranda, that the Office of Legal Counsel, the same office that John Yoo worked for, did a couple of years ago that apparently supplies the legal reasoning for the administration to be able to single out individuals and have them killed without any criminal proceedings of any kind. The government has refused to provide that memorandum, or those memoranda, to anyone. They're classified. Nobody can see them. The ACLU and others have filed a Freedom of Information Act lawsuit attempting to get them. A judge very reluctantly a few months ago said that can't do that under the Freedom of Information Act. The government says this is classified national security information, and I can't go beyond that. Case is on appeal now. Very troubling that our government is preventing us from seeing not who, what, when, and where in the way of what we're about to do. You can imagine why you need to keep that secret. But what's the legal justification for this kind of enterprise? The government says you can't see that. Well, this white paper that came out a couple weeks ago was not classified and is not apparently the definitive legal analysis. But here's what it says. It says that killing a United States citizen who is a senior operational leader of al-Qaeda or an associated force who is planning operations to kill Americans is justified. That's lawful. If three conditions are met. One, an informed high-level official, not saying how high, who that might be, an informed high-level official has determined that the targeted individual poses an imminent threat of violent attack against the United States. That's one condition. I quibble with the language a little bit there. Who cares if it's an imminent threat? It has to be imminent harm under Brandenburg, not just a threat. Anyway, second condition, capture is infeasible. That is, a better alternative than going in and zapping the guy would be to capture him. Capturing is infeasible, and the paper says the U.S. continues to monitor if capture is feasible. So things might change. If it becomes feasible, then you shouldn't kill him. And third, the killing is conducted in a manner consistent with the laws of war, which I take it to mean no torture, no horrible kinds of killing. And the white paper says that the president gains his authority to do this from several sources. His constitutional responsibility to protect the country. I mean, the Constitution does make him commander-in-chief. The inherent right to national self-defense. The congressional authorization of the use of necessary and appropriate military force against this enemy, Al-Qaeda. That apparently is referring to the 2002 force resolution passed by the Congress to invade Iraq. And finally, the existence of an armed conflict with Al-Qaeda. And the white paper concludes that a killing of an American citizen even in a foreign country under these conditions is not an assassination because a lawful killing in self-defense is not an assassination. Well, I think it's unfortunate, and I do think that the administration owes it to us Americans to tell us what the real rationale for all of this is. Let's turn to a related subject. It won't be national security at the moment, but that's coming up. Nicole? Independent advocacy? Doing it on your own. These are my views. I'm not paid by anybody. I haven't talked to anybody. This is me talking. I have a First Amendment right to do that. What the government is saying is you don't have a First Amendment right to sit down with a terrorist organization and figure out how best to present their case to the United Nations or something like that. Just operating on your own. Something right there? No? Boost up the volume, please, Ruby, because they can't hear you back
I
there.
think it's funny how Robertson used the fungible argument does not apply to the Citizens United case, and that's really interesting.
Oh, wait a second. Spell it out for me. The fungible argument does not apply to the citizens.
Citizens United case because it frees up other material resources.
Oh, yeah. Why doesn't that very notion apply to the Citizens United thing? Yeah, well, Chief Justice Roberts, it was the same year that the two cases were decided, but he must have forgotten that that principle could be applied in other contexts as well. That's an astute observation. Let's go to Neer, the great case of Neer versus Minnesota. And the subject here is prior restraints, restrictions on speech before the speech can be heard, before it can be uttered. What we colloquially refer to as censorship, government censorship of speech before anybody hears it. Remember the Sedition Act. The Sedition Act made it a crime to say anything that was false, scandalous, or malicious about the government. That was not a prior restraint. That was a garden variety criminal law that provided punishment after the fact. If you had criticized government, then you might be prosecuted and sent to jail after you had spoken. That's not a prior restraint. Prior restraint is the most dangerous threat to free speech because it occurs before the speech is heard and it anticipates whatever harm the government thinks the speech may cause. It involves a prediction that harm will result from this kind of speech in order to shut it down, rather than with a criminal law punishing somebody after the speech has been uttered and you can see what harm, if any, has been done. And the Sedition Act, of course, died in the court of history. It was a serious restriction on speech. It might have frightened people, deterred them from speaking, but it didn't prevent them, in the first place, from speaking. The framers of the Constitution were well aware of the issue of prior restraint, because prior restraint in its classic form was exercised in England up until 1694, where printers were licensed by the Crown. You couldn't set up a newspaper. You couldn't set up a print shop and print books or pamphlets without the permission of the king. And the king had a censorship apparatus, bureaucrats, whose job was to review copy before it was published. And they would say, you can't say that, you can't publish that, or you may publish this. And that was an infamous and unpopular notion. And finally, in 1694, it was abandoned in the UK. But the framers of the Constitution knew about that history from less than a century before. A famous English legal scholar by the name of William Blackstone had written a treatise about what the common law is and what the law is in England and so on, and had said that prior restraints are not permitted. He's writing at the end, or near the end, of the 18th century, the late 1700s, referred to that history of the old day, the bad old days of censorship are over. Now people have a right to publish their sentiments as long as they're willing to take the consequences after the fact. So the distinction here between prior restraints and other restrictions on speech, like criminal laws or libel suits, is the latter, criminal punishment, damages for libel and so on. Those are subsequent punishment, not prior restraint. Prior restraints is the subject for the rest of today and Thursday, leading through the great Pentagon Papers case. But let's start with Near. J. Near. This is a wonderful book, by the way, Fred Friendly's quick read about the Near versus Minnesota case and how it happened. J. Near was a newspaper editor and publisher in Minnesota. He'd grown up in the northern part of Minnesota and had been involved in a couple of newspapers that were basically scandal sheets, borderline extortionist operations, where isn't literally so, but the kind of thing they would do is the newspaper publisher would talk to the bank president and say, you know, one of our reporters has pictures of you going into Susie Q's brothel last night, and we really don't want to run that kind of a story, but it would be big news in this community, and we hope that you'll support the newspaper by committing to a year's worth of advertising in our pages. If you do that, I think we can bury the story. Borderline extortion. That was the kind of newspapers, so-called newspapers, that were notable in early 20th century northern Minnesota. J. Near started his own newspaper in the Twin Cities, Minneapolis, St. Paul, in the mid-1920s, called the Saturday Review. And its specialty was raking over the coals and embarrassing the local establishment, the mayor, the chief of police, the prosecuting attorney, and other local officials. As you see in the excerpt in the Reader, Near was virulently anti-Semitic, and one of his main claims, made in issue after issue of the Saturday Review, was that the city officials were being bossed around by Jewish mob bosses who were really running the city. Had the chief of police in their pocket, Mose Barnett was running the city, not the actual mayor. And after 9 issues, weekly issues, of the Saturday Review, the local authorities brought a lawsuit under a new Minnesota statute that had been enacted to deal with this so-called yellow journalism phenomenon. It was colloquially called the gag law, and it was an ingenious piece of legislation. It treated newspapers that publish false, scandalous, and malicious material as a public nuisance that could be abated. Nuisance is an old, ancient concept in common law. I mean, when you think of a legal nuisance, a public nuisance, you think about a dump in a residential neighborhood, or a house of prostitution, or a loud bar, or something that disrupts the peace and tranquility of the neighborhood. That's a nuisance. Pollutes the river. The nuisance can be abated. That is, the authorities can go to court and get a court order enjoining abating the nuisance. Stop doing that. Well, under this Minnesota law, the state had decided that anybody who was in the business of publishing a malicious, scandalous, and defamatory newspaper was guilty of a nuisance and could be enjoined. Yes, it was a theoretical possibility that as a defense, you could prove the truth of what you were saying, so long as you proved as well that what you said was done with good motives and for justifiable ends, which was a common law concept drawn from libel, where truth was a defense to a libel suit, and in many states the truth had to be published with good motives and for justifiable ends. Well, J. Near got sued by the local authorities under the nuisance law. The case brought by the authorities consisted entirely of the 9 issues of the Saturday Review that had been published. That's the case. Here it is. And the judge concluded that J. Near had published a malicious, scandalous, and defamatory newspaper. Malice could be inferred from the content of the material. So could defamatory meaning, accusing public officials of serious misconduct, being in bed with the Jewish mafia. And scandal as well could be inferred. It was real easy. Near did not put on a truth defense. His defense was, I'm protected by the First Amendment in publishing this material. And the judge, in effect, said, thank you very much. I find that you're operating a nuisance. You are enjoined from publishing. Put under court order not to publish. And the Near then, the case, that was a preliminary injunction. They went to trial. Same evidence was presented. The judge issued a permanent injunction against Near's publishing his newspaper. The case went to the Minnesota Supreme Court, which affirmed the decision. And then Near happened to find help from Colonel McCormick, who was the publisher of the Chicago Tribune and a major force in American political life, and somebody who was very interested in establishing freedom of the press from any kind of restraints. And McCormick was concerned about the precedent that might be set here, and that other